Hello and good evening, everybody. Welcome to another edition of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy ARDOIN, along with my co-host, Julio Vela. What's going on, man?
Jimmy, a week off's too long, man.
It is. So much has happened.
I missed you, man.
We've had 2 conventions now.
Yeah.
A lot of other stuff going on. We got to go up against Hillary tonight.
I know.
How you feel about that?
Well, because we have Amber Spurlock and Sean Buckley, I like our chances. Just saying. Just saying.
Hopefully we get some people to tune in before turning over to watch HRC's speech. But yeah, as Julio said, we welcome Amber Spurlock and Sean Buckley to the program. Thank you guys for joining us.
Thanks for having us.
Absolutely. Absolutely. We'll be on air for the next hour, taking your phone calls. 713-807-1794 is the number. You can call in starting around 8:30. We'll also take your questions and comments via Twitter at HCCLA_TV. Like we said, a lot of stuff has happened over the last couple weeks. The biggest has been the now national and international news story from right here in Harris County. That being that a rape victim, who shall be known as Jenny, was jailed at the Harris County Jail because prosecutors feared she would not return to testify for trial. There's a lot of details we want to get into about this case, and Sean, we're lucky to have him here tonight because Sean is the attorney representing the victim in this case. So, Sean, we really appreciate you making the time to come on because I know this is a real sensitive issue and you're doing a lot of work on the case right now. So,
how did you come to you?
Yeah, that's the big thing. How did you first get approached on this case?
Well, I heard about it, Julio and Jimmy, from another lawyer on the civil side of practice who knows this young lady's mother. And her mother had become exasperated through numerous attempts to try to get justice for her daughter. And in fact, while her daughter was in jail, to try to get her out of jail, and had just been plowed over by the system and ignored. And so she came to her friend, who's the civil lawyer, and talked to her about, hey, what do we do? And the civil lawyer and I have worked together before, and so that's how I ended up with the case.
You know, I get, and I'm sure all of us do, but we get people wanting to sue Harris County, clients wanting, you know, who are jailed and beaten up in there, and evidence was planted on them, and they're roughed up by the cops, and they always want to sue Harris County. And you know, I always tell them, sorry, good luck, man. I mean, it's outside of my wheelhouse, but I doubt you'd find anybody on the planet who's going to go up against the juggernaut of Harris County. And so I'd imagine when they came into your office saying, yeah, you know, I want to sue Harris County, I mean, it would take a certain kind of individual to say, let's rock and roll, let's go on this.
Well, you know, I cut my teeth on civil rights cases years ago. 15, 16 years ago, I started out doing this, representing often people who had been over-criminalized and disadvantaged by the state of Texas or the county. And so I abandoned that part of my practice years ago and became a criminal defense lawyer. But I know how to do it. I've done it before, litigated against the state of Texas and other municipalities. So when this case came to me, it was, I was not intimidated by the subject matter. I was concerned that the story that was being told to me could not possibly be true. It just seemed so outrageous. And so I began working to verify the facts. And not only did I verify all of the disturbing facts, I uncovered many more. And at that point, it became a no-brainer that this was something that needed to be done and that I needed to make the decision to devote my practice to this case.
Now let's kind of go through some of the facts because, I mean, it's been well reported both in the national, the local, even the international media. You've had some coverage over in the UK and elsewhere on this case. But essentially what happens is your client is a rape victim. She was, as I understand it, and correct me if any of the facts have been misreported because I'm going by a combination of your petition and the news media that's out there, but she was a rape victim. She was at one point, I guess, living on the streets, not technically homeless, but at one point she was living on the streets and she was raped by a man out on the streets.
Yes.
Who was a serial rapist.
Yes.
The state had been after him for a long time.
Yes.
And she was prepared to come to court and testify, but she has had some history of and had some battles with mental illness.
Yes.
They get to trial in this case. They start trial in the case. and she's put on the stand and has a little bit of some, a mental breakdown, for lack of a better term to call it. I mean, she has a mental breakdown on the stand. That's not unusual in any kind of case, frankly, but I think it's heightened in this case because of her mental illness. It's very hard for victims to confront their accusers.
Well, and the prosecutors in this case waited till the last minute to prepare her to testify when they knew that she has a bipolar diagnosis, she has symptoms of schizophrenia. They knew she was a delicate soul, and because frankly they were lazy and reckless, they waited to prep her until the night before her testimony, and that was the beginning of this tragedy for her back in Harris County.
And so at that point, then I guess she disappears, and they find her out in the street.
Yes.
Outside the courthouse, and she's making rumblings that she wants to leave, she doesn't want to come back, she's not going to come back.
And she's having, at this point, Jimmy, a full-fledged mental breakdown.
Right. And so the prosecutor, and I should say, the facts are she was not subpoenaed as a witness. She was there, she had come on her own free will to testify. There was not an actual subpoena in place.
You're right. There was no subpoena, and she was also a resident of another county, which is something that's interesting and extremely important in this case.
Wow.
And so at this point, the prosecutor becomes very concerned that she's not going to come back when the trial resumes. And so he takes the extraordinary step of filing for what's called a writ of attachment. And this is a process, it's a legal process, in which the state or even the defense, any party can seek to have a witness attached to a case and either held in custody or put on a bond to ensure their appearance to testify in court. The prosecutor does this, approaches the judge, gets the judge to sign off on it, and she goes into custody in the Harris County Jail. She doesn't get a bond.
27 days.
Yeah.
There's a bond set, Jimmy, but she does not have the money to make the bond.
Was it a $15,000 bond?
It's a $10,000 bond. The prosecutor at some point misrepresented to her mother the amount of the bond and lied to the mother to dissuade the mother from bonding my client out of jail, and that was done on Christmas Eve. The prosecutor lied to my client's mother on Christmas Eve.
Isn't that all? And it's all documented to email?
Yep.
Wow.
I mean, this is just, it's an extraordinary step to me because usually writs of attachment are done on an actual witness who's under subpoena, which you didn't have in this case. And as you alluded to earlier, you have to, the witness has to be a resident of the county. And she was neither of those.
Neither of those. It was an illegal attachment order. It was just as illegal as if I go and kidnap you on the streets of Harris County and throw you in the Harris County Jail for 27 days. It was akin to a kidnapping, frankly.
Now, is the illegality because she lived in her residence was in another county?
Not solely, but when a witness is not under subpoena, the only other way to attach that witness is if they are a resident of this county and you have reason to believe that they're leaving the county. Otherwise, the witness always has to be under subpoena. Neither of those options applied in this case.
Did the judge know that? I mean, was the judge aware of this, or was it?
My position is, based on my investigation, that the DA's office misled the judge.
Amber, you were a prosecutor.
I was a prosecutor in the military.
Right.
Right.
And I'm sure, and I think you were also a special AUSA. I looked at your resume, by the way, before you came on, because this is obviously the first time we've had you on the show. So I do my homework on our guests. You have quite an extensive resume. You've done some pretty cool stuff.
It's been a very busy past 10 years, I guess. Very busy.
Do you recall when you were a prosecutor having a procedure in place for getting writs of attachment on witnesses?
You know, really, we didn't really have these issues, for one, especially in a military setting, because when you're talking in a military setting, I mean, the nature of just an order is, especially when it's coming from a higher officer, I mean, that in itself is something you don't disobey. And so I think the structure of our military justice system is much, much different than the system that we have here. And that was actually one of the things that was so hard for me coming back from the military, is the relationships that you have within the court system are very rank structured. And there's a lot of oversight and there's a lot of command that goes down. And like, for example, when you're prosecuting a criminal case, you're actually working with a commander of the person being prosecuted. So there's this different element that's in there. So coming back to the state system, it was very different to have something that was so much more casual, I guess, in a sense, where you can actually have a witness that doesn't show up. That is kind of unheard of, you know, for us in the military system. And so, you know, when we do subpoenas, because we do subpoenas all the time, and someone just doesn't show up to court, especially when we're trying to get documents. You know, we'll send the subpoena, please provide me with all these records and recordings, and you go, you haven't heard from the person, and you show up in court on the day, the return date, and no one's there. Or you're there for a hearing and they don't show up. For us, in the military setting, that doesn't really happen that often, or at least I didn't have that problem. I see it a lot more in the cases that we handle in the state courts.
What's interesting here, Sean, is I don't see, and look, I'm gonna kind of play devil's advocate here because, you know, Devin Anderson has gone out. She made a very, probably an ill-advised videotape statement that really didn't convey the empathy that I think she probably truly meant to, you know, based on her subsequent interviews. I think she probably should have waited before doing that taped interview. But I really don't believe in my gut that she was advised of this or knew about this.
I believe that you're right.
Till the end.
I think you're right.
Until things went really, really wrong. And what that speaks to me is, unlike what you're talking about, Amber, is a lack of structure and a lack of, you know, procedures to be followed in this situation. And that's what's really concerning to me, is the possibility of that.
In your experience, did you ever prosecute individuals accused of rape, and or serious crimes, and how would you handle these types of witnesses? Did you ever come into a situation where you had to, you know, be maybe a little bit more delicate with the particular type of witness, or what type of things would you?
I mean, honestly, this situation actually brings back an instance from when I was in the military, and it wasn't actually a case that I was handling, but we were on call. So you have your on-call JAG, and you have your on-call phone, and if something were to happen, you know, a commander can call you, or security forces can call with a question. And this particular instance, this young lady had been in Korea, and so she was there with her unit, and was sexually assaulted. Well, and I know we see in the news all the time, you know, the issues with sexual assault in the military, and they're real.
It's a big issue.
It's a huge issue.
And there's been a big issue, Amber, with victims not wanting to come forward in the military too.
Yes, and some of the problem, I could go on for days actually, but some of the problem with that is when you have a unit, and these people, a lot of times the sexual assaults in the military are happening within the same unit. So it'd be the same as, you know, someone in, you know, working for Office Depot sexually assaulting someone that works at Office Depot, and that's where you go every single day for your work to make your living, and that's your life. And they're in that same, you know, close quarters. And so that's one of the things I think that makes the military so difficult, because then what happens? What do you do? And so for this particular young lady, she had been separated from her unit instead of the young man separated from the unit, because they were in the same unit. Well, long story short, because of the impact of the incident, she tried to harm herself. And she ends up getting sent back to the States, and she was actually where I was. And she's back with her home unit, and it happens again. Because of all the pressure, because the prosecution's going to be coming up, and again, it wasn't one that I was prosecuting, it wasn't my unit. But when the commander found out that she was, you know, going through these issues, the first thing they thought of was, let's call the on-call JAG. I've got to get her committed into a hospital. Like, it's got to be done now. Take her now. And it sounds a lot like that's what happened with your client, is there's not that take a step back. How can we actually address what the issue is? Because the issue, I mean, if she's in court testifying and she's being prepared for this case, your client, then she's participating. You know, she's wanting this to go forward, at least voluntarily.
Yeah.
And if there's the knowledge that she has this mental health issue, and all of the pressure of it is actually bubbling and it's coming to the surface, then the same thing that happened with the young lady in the military, you've got to take that step back initially and say, how can we address this problem, rather than scoop them up and throw them behind closed doors and forget about them. Like that quick fix isn't a fix.
Very well said.
Yeah, and you know, the biggest issue I have with this case is the fact that as a prosecutor, whether you're a line prosecutor who's a number one, or a chief, a number two, a number three in your court, whether you're a supervisor or whether you're the elected DA, the fact that anyone would even consider the possibility of putting a sexual assault victim in jail, like that just blows my mind. Like where does it even come into the equation? Like, we have no other options, so we think this is the best option available to us. Like that, I just don't understand the thought process there, when there has to be something else that you think can be done.
Especially when, and correct me if I'm wrong, there was such a lack of oversight and everything. From what I was reading, all of a sudden her status is not a victim that's in jail. She's actually the status of an offender.
Right.
And so you have so many things that just from putting her in the jail, so many things went wrong after that, that just led to this disastrous experience that basically re-victimizes her all over again. And now it's all in the news, and we're doing it again. And now it's being used for, campaign purposes, and it's going to happen again. And it's all, it goes back to what you said. Who in their right mind would think, I'm going to take a victim who is emotionally fragile and put her behind bars? We're all defense attorneys. None of our clients want to go back to jail.
No.
Much less the victim.
Well, we all know in Harris County, if you go to Harris County Jail, you could die.
Yeah.
You could die. It happens all the time. It happens at least once a quarter, at least a couple times every year. We're hearing about somebody dying in jail. You get beat up. You contract all sorts of things. So let's see where we're at. So they issue this writ of attachment, and then what happens?
Well, and then she goes into the jail. She spends a few days in the hospital being treated for this mental breakdown that she had. When she's discharged from the hospital, the district attorney's office comes to, not the whole office of course, but an investigator employed by that office comes to the hospital, arrests her, and takes her to the jail to be booked in. When they book her into the jail, as Amber explained, they book her in a way that falsely shows her as being a defendant in a sexual assault case, not the innocent victim.
A rapist.
A rapist.
So she goes into Harris County Jail with that label on her.
And when she goes to get treatment in the medical section of the jail, they don't understand why she's confused about her status. This woman was booked in as a sexual assault defendant, and she keeps claiming that she's an innocent victim. She's disoriented, is what they said.
And did someone, I thought I read somewhere that not only did that status affect, just interactions with jail staff, but didn't that affect her medical treatment as well?
I believe it did.
Okay.
I think she would have gotten better treatment and more humane treatment, and certainly better conditions of confinement if they had understood that she was the innocent victim. My position is she should have never been in the jail to begin with.
Well, and the sheriff has come out and given his own statement. He's really thrown the DA's office under the bus. That's putting it lightly. What he said.
I think, frankly, and as you all know, I'm trying to hold the sheriff's department accountable for what they did to my client while she was in the jail. But that being said, I am satisfied that had the DA's office called Sheriff Hickman and told him what they had intended to do with my client, he would not probably have gone along with it. I don't think he would have gone along with it. And I think that's why that call was never made.
Well, and I don't think anybody can agree with the call, at least on its face. Even beyond that, it's ludicrous. It's just
the call to even think that you should file a writ of attachment on a victim is absurd to me. It just is. I don't know what goes through your process to say, all right, you know, I think it's a great idea that I throw a victim in jail. Like that just doesn't make any sense to me whatsoever. I've never been a prosecutor, been a lifelong defense lawyer, and I can't even grasp that. I can't grasp the fact that as a prosecutor, when your job, when your mantra is that we get justice for victims, how you can even think that putting a victim, a witness victim, under attachment, where the possibility that that person is going to end up in the Harris County Jail of all places, how that even crosses your mind is just beyond me.
Well, I'm glad you said that, the whole thing about you're seeking justice. I mean, after doing this for, I've been back from the military, I guess, five and a half years now, which isn't that long, but it's long enough. The whole concept of justice, it seems like, has changed into this concept of convictions at all cost. And that, I think, is what is really scary.
It is.
Because when you take an oath to see that justice is done, justice is not throwing a victim into jail for the sake of a conviction. Granted, a conviction in this case is absolutely the right thing, but that's not justice.
And I think you have an interesting point, Amber, because if the system is willing to do this to an innocent rape victim, what are they willing to do to other people who get in the way of a prosecution?
It's just vigilante. Like, it's straight vigilante justice operating outside the bounds of what was allowed by law to put a witness in jail, to seek a conviction, not justice. You know, I was watching, my kid has seen Zootopia for the 2000th time, and I've watched him with him. And at the end, so there's a mayor, and he's the lion, and he ends up getting ousted because he was sponsoring locking up these innocent animals because they were going savage and going crazy, and he had it all under secret, right? And at the end, you know, they're interviewing the lion, and he says, you know, it's just a classic example of doing the wrong thing for the right reason. And, you know, it's supposed to be in jest, you know. No, the means, if they're not just and they're not right, that end isn't either. Mm-hmm. It's just baffling to me. It's straight vigilante kind of justice, and I think you're right. When Devin came out back with that response, it was a complete and utter reaction. It showed no sympathy or remorse, and it was just, I think it was happened too soon. She should have taken a breath.
Well, you can see even in her video, like her jaws are clenched, and there's just so much tension there.
And anger.
Yes,
Yeah.
yes, you could see it. She was angry.
I don't blame her to be angry because, like I said, I don't believe she knew about this until probably the very end. And she has every right to be angry because you know who's going to take the political heat for this? She is. The buck stops with her. And rightfully so. I mean, look, you want to put yourself out there and be an elected DA, you're going to have to deal with this. But from another standpoint, too, that I think should have been done, is the prosecutor who did this should have been put on administrative leave. Bottom line, period, end of story. Should have been put on administrative leave. There's no reason why. Pay him. That's fine. Put him on administrative leave with pay. But you know what? When you do something like this, it smacks of bad judgment, okay? It's poor judgment. You may be able to legally do it, but it's bad judgment. And he should be put on administrative leave pending an investigation. She says there's an internal, investigation about everything. We'll put the person who did it on administrative leave.
Well, here's what I still can't grasp, is how a prosecutor cannot dismiss a criminal mischief when restitution's been paid for a defendant who has no criminal history whatsoever without asking somebody, but a prosecutor can throw a victim in jail and no one up higher knows about it.
That's a great point.
I don't get it.
That's an excellent
I don't get it. Restitution's paid, no criminal history. This is an easy one. Oh no, I've got to go talk to my chief. I've got to get this person to approve it. It's like, good Lord.
Yeah, you want to get a dismissal on that, or you want to get a pretrial diversion on a no-brainer, you got to go through about 8 levels of checks.
But hey, if they want to throw a victim in the jail and leave her there.
Make your writ of attachment.
Yeah, that's an easy one.
Make your illegal writ of attachment. Right. So she has a mental breakdown in the jail, is that right?
She did. She did.
And I think, so she's accused of maybe of striking an officer, or?
Well, she was having a mental breakdown again in the jail, a psychiatric episode. and she was pleading with God to rescue her. And it was loud, and it brought the jailer's attention to her cell. But instead of using a protocol that you would use in a mental hospital for protecting a resident who's having an acute psychiatric episode, they used a protocol, which wasn't even a very good one, for containing disruptive criminal defendant inmates. And so they escalated a confrontation with her that turned physical, and they ended the confrontation with a closed fist hit to my client's face. And they've admitted that.
And please don't tell me they filed charges against your client for that.
Of course they did.
And guess where the case ended up originally?
Where?
In front of Judge Bond, who promptly recused herself.
What's going on with that one? Is that still going? Or
No, it was they continued prosecuting her until she testified again against her rapist, because they didn't want it to look like she was getting a special treatment by them dismissing this case against her.
So basically her dismissal was contingent upon finishing her testimony.
Well, no, I don't think it was. I don't think there was a contingency.
It just played out that way.
They just didn't want to give the
They
defense
did not want to
lawyer
give it
ammo.
to her. And let me say this: she testified truthfully. She testified truthfully against her rapist. There's no claim from us, from her, that she was coerced into giving a statement, that she was coerced into testifying in a particular way. She told the truth. Our beef is the way she was treated.
So, for 27 days?
27 days.
She provides the testimony, and then what happens?
Well, and keep in mind, this is over the Christmas and New Year holiday.
Oh, gosh. Okay.
And they didn't want to deal with it because they were on vacation.
Wow. The client.
Wait, who was on vacation?
The prosecutor's office and their victim services people were on vacation over the holidays. That's my theory of why this happened. They didn't want to work and help this lady with her psychiatric difficulties. They figured, well, let's just put this responsibility off on someone else.
Well, and the prosecutor did it. His name is Nick Socius. I've never met him. Don't know him. Maybe.
I know. Look, on the record, I like Nick.
I've heard he's a nice guy.
When I found out it was him, I still can't believe. I think Nick's a good guy. He's always played above the board with me. I've had a lot of cases with him. We just have to reserve. I'll reserve.
I've heard everybody tell me the same thing. And one of the difficult things that comes with my role in this case is that I have an absolute duty to my client to engage in suit anyone who I think must be sued under the law. And so I've had to direct this suit at places that I think are uncomfortable and at places where people, maybe for everything else that they've done, don't deserve it. But I have an absolute duty to see that she gets justice.
Well, there's a chief in that court too. I mean, like I said, I don't know. I couldn't see Nick making this call without some sort of something.
Well, and I'll tell you this too. When I came into contact with my client for the first time and agreed and gave her my word that I was going to see this through, I didn't know who was involved. And as I've learned, as we've gone forward, it's been to some degree difficult for me to deal with that, but I will keep my word to my client.
Well, but here's the thing.
And you have to. I mean, you have to.
Well, and look, I don't know him. You know him. You think he's a great guy. It may very well be, okay? I know a lot of great people who have made mistakes. Bottom line, I make mistakes. I think I'm a great person.
Well, you are, Jim.
And I've made mistakes. And I will own up to it, okay? And, you get in this business, you get in the legal business, you're representing people. Mistakes happen, as a defense attorney. You may make a mistake on a case, and guess what? The lawyer who looks at it after you on appeal or the lawyer who looks at it on the writ afterwards, they're going to call you out on their mistakes. And you can either be a big boy and you can own up to your mistakes and say, yeah, you know what? I screwed up there. Shouldn't have done that. Or you can take the tactic of,
Which is what Devin should have done instead of.
Exactly. The video was awful because it's too many of making excuses and rationalizing why everything's okay, as opposed to the later statements of, we really hate this happened. And
The no other option thing is baffling to me. Here's for a number of reasons. The first one is when I do a lot of court appointments, they come out, and if they're homeless, each of them are getting sheets about where to go afterwards, and I've called myself, and it's not that difficult to find some help when these individuals get out of jail. Okay, so the idea that, oh, well, we gave the Women's Center a call once and they said they were full, and then they come back, Women's Center's like, no, you know, believe me, I've called the Women's Center and they said we're full, and I said,
I tried to call them to get them on this show. You know what I got? We are helping other people. I mean, I never got a live person on the phone.
Well,
so we'd love to get you on Houston Area Women's Center, but you know, pick up the phone.
the other thing is like, seriously, you fly district attorney's office experts in from across the country for DWI blood. They're sending some of the blood out of state, and when we have to go to trial, they're flying these people in, sitting in jury trials to testify, and you can't find a place to put a victim who's arguably, you know, not necessarily more important or not, but a special circumstance to put them up, find a place for them to stay. Harris County Jail is the only place you can find. I think it's absurd. I think it's a sorry experience.
We've hit the halfway point of the show. So if you got a question, comment, you want to get in on this conversation, call us 713-807-1794 is the number. We'll take your call right here on the air. You know, you say that, Julio, about treating victims this way and not being able to find a place. I've seen people who are charged with a crime treated better, who have been put up at hotels by the U.S. Marshal prior to their detention hearings in federal court. And they've got the Marshal's office bringing them hamburgers from Wendy's the night before because they don't want to put them in the FDC because they're concerned they're a high-profile defendant. They may get the crap beat out of them at the FDC. You know,
You're right.
That's what's so amazing about this, is I have seen people charged with crimes treated better than the victim in this case. And it's so odd because, you know, the four of us as we sit, we're usually on the defense side. So we're usually the one cross-examining victims and trying to poke holes in the story. So it's an odd place to be where we sit right now, where, you know, we're kind of, and Sean, you've put back on your civil rights cap on this case. So it's an odd place to be.
It's because as criminal defense lawyers, we also have a philosophy about how you treat people and how you treat the little guy who's got the system gearing up on him. And that's what we do every day as criminal defense lawyers. And we do the same thing when we put our civil rights hat on. And it may be a different type of person that we represent, but the dynamic is the same. A little person without power against the big power of the government.
Well, I think it's just the general concept of humanity. I mean, that's why this story is so offensive, because it doesn't matter if you're a criminal defense attorney, it doesn't matter if you're a prosecutor, it doesn't matter if, you know, you work down the street at, I don't know, Jack in the Box. The bottom line is it's humanity, and it's, like you were saying, it's just how you treat another person.
Well, and so much of our conversation on the TV show lately has been about police abuse and abuse by prosecutors and, you know, on the people in the system. And this is just one more story of it.
I'm wondering how much more can Harris County take? I mean, this is ridiculous. It's getting absurd. Like, people are dying in the jails. Victims are being locked up. I mean, it's just, what's next? I mean, people, we have the largest mental health facility in the country here. I mean, it's just, you know, it's the mentality. It goes back to what you said. I mean, it's just.
And that's the problem we've got right now. I mean, everybody knows that our jail's a wreck, okay? The whole world knows our jail's a wreck. I mean, it is broadcast loud and clear from the mountaintops everywhere you go. And I think that's also part of the problem here. It wouldn't have been hard for somebody at the sheriff's office to find out what the real story was.
You know, and it also ties into something else, Jimmy, and that is that everyone involved in this case and everyone who works in the Harris County criminal justice system knows and has known for years that the Harris County Jail is a miserable dungeon.
Yeah.
And so the whole concept of putting a rape victim in there is obscene and absurd.
It's 12 Monkeys style. You know, imagine you have a mentally ill person going into jail saying, I'm innocent, I'm the victim, and everybody's saying, no, you're the rapist, who wouldn't have a breakdown?
It's something out of a Kafka novel
It is.
or one of those 70s B horror movies where someone ends up stuck in an insane asylum.
You know, and you referenced that in your petition, the Kafka novel, and I got to say, the writers out there who are covering this story, please get some original material because you keep stealing Sean's
Actually, I've seen
Kafka
that. I think
reference in all your articles. Come on, you guys went to school. You're supposed to be journalists and masters of this, and they got to steal your line, man.
I don't consider it theft. I consider it inspirational.
you know, we're lucky that it only got as far as it did. I can only I mean, you know, it's the mentality. I was setting a case for trial a couple of days yesterday, and you know, it's that office. You know, they said you're ruining these kids' lives. They were 18, 19. You're ruining them because I was setting their case for trial. You're ruining their life because they're going to get convicted. And it's amazing that when we set a case for trial as a defense on the defense side, because we think our case has merit and we think that we're going to hold the state to their burden, that we think we're helping and we're looking at how we have compassion and humanity. These individuals do not need to be in any one of your probations or programs. However, that's not how that side looks at it. They think we're hurting them by setting it for trial.
Yeah.
It's literally just and you know, you just got to look at them and say, yeah, we're going to go ahead and set this case for trial. Well, why? So because they didn't do anything wrong.
Yeah, I had a young kid in Galveston that was charged with possession of controlled substance and pills. And he was adamant, they weren't mine, I didn't do this. And they had offered him, he had no criminal history, they had offered him the 3-step program that they have down there. And my client turned it down, and so we set it for trial. And just reading the facts over once, and I say facts lightly, I read the offense report, there was no way they could make the case because truly they weren't his. And the DA was so nasty to me, just nasty, because I was setting that case for trial and he wouldn't do that 3-step. And he couldn't grasp it. And from then on, for that case, it was just this battle back and forth that I was doing something that was just horrific. And I was like, no.
Well, you know, the interesting thing here is we're 90 days from the election. We're going to have Kim Ogg on next week, the Democratic challenger, who has already come out and given her statement on this. She's asked for an independent investigator. But you've got the sheriff pointing fingers at the DA's office for dropping the ball. You got the DA's office pointing fingers at the sheriff's office for dropping the ball. They're fighting with each other. The DA's office has just charged a couple deputies who the Sheriff Hickman came out and said, we cleared them in our investigation. I don't understand. So there's tension right there right now. And then yesterday we get the dismissal of the Planned Parenthood charges. And, you know, I read the dismissal notation.
Mm-hmm.
I couldn't
I did. I went online and printed it out. And you've got to be kidding me.
About how the grand jury exceeded their authority.
Yeah, and they had, what was it, what did they call it?
Colorable claim.
Colorable claim?
Yeah.
It's almost like, well, I mean, I guess their claim could be all right. That
if
maybe
they would,
the grand jury did something.
If they would dismiss a case every time I had a colorable claim of a defense,
Exactly.
I'd never try anything.
No.
And how about the drugs weren't mine? Like, that's not colorable
No,
enough.
not at all. That one didn't work.
But it is, the timing of the dismissals is very convenient, in my opinion. You know, comes a few days after the firestorm of your case, Sean. The reason given about how the grand jury exceeded their authority and may not have had probable cause to indict this case in the first place, or, you know, it was a flawed indictment and that they had the wrong language. Well, how many times has that stopped them before from just going in and re-indicting the case?
Yes.
You know?
That's what they do.
Yeah. So the timing of this is very suspect on everything. And look, as a defense lawyer, I don't begrudge any defense attorney for getting a dismissal on a case.
Right.
You know, we root for the defense because it's tough to get victories on this side of the bar. It just is. And so, you know, we root for either acquittals or dismissals, and you clap them when you get them. You clap for your companions and your brothers in arms when they get these things. But it is troubling that this seems to be, it was a politically motivated case from the start, and it ends as a politically motivated case. I don't think there's any way, and they can write about colorable claims and grand juries exceeding their authority all they want, but the bottom line is this was politics from beginning to end.
Absolutely.
And it's very troubling because we're heading into this election season that has all sorts of uncertainty. And it's just crazy. It's crazy what people are doing right now. And I want to get to what's going on down in Galveston.
Oh, this is painful.
Because this dovetails into all this.
It's so painful. And it does. And I was on vacation when we're talking about the Judge Neves down in the 10th District Court in Galveston.
Yeah, for those who don't know, Judge Neves, is that
Judge
who?
Neves.
Okay, and
yes.
I understand he might have been a city council member of League City prior to taking the bench.
That I honestly don't know.
Okay.
I probably should.
I don't
I'm in his court all the time, but I don't.
Somebody told me that. Yeah. But last week, I guess it was last week, since we were off, I'm having problems with my calendar and timing at this point. He makes a post on his Facebook page, on his judicial Facebook page. And this is after Dallas. This is after Baton Rouge, where we've had officers ambushed. This whole war on the police has been escalated again, so to speak. And so he puts on his Facebook page that he will not consider plea bargains in cases where police officers are victims and they've been assaulted,
threatened,
from?
endangered,
Yes.
endangered in any way. I mean,
yes.
it's a laundry list of things.
That he will not consider probation. He will not consider deferred. So basically, it's if you're accused of this, it's an automatic prison sentence. But then he has this, later on he says, but I may consider it if the defense and the state can come to me with something that's really compelling. I mean, if you can really convince me. And then, even if you convince me, the officer who's the victim has to sign off on it. So now it's not just a state and a defense type issue, it's a state defense, and we've made the police officer, a party to what happens as a resolution of this case. And
presumptively agreeing with the charge that he is the victim.
Exactly. And then the kicker, I mean, not that this isn't bad enough on its own, but the kicker is that the person accused now has to write an apology letter and actually read it in court to the officer. I mean, oh God, there's so many things to say about this.
Doesn't that break some, canons of judicial conduct? And
I just got one question.
Well, you know what's funny?
What the hell is wrong with people in our system? What is wrong? I mean, has just all logical, sane thought. I mean, it was already borderline out the window, but it seems like between what went on in your case and this Facebook post, I mean, it's just like all sanity and reason has just left the building.
It's completely gone. And it's so bad that you can't even have a conversation about it that makes sense. Because if you're trying to talk to the person who's behind it or doing it, it's like talking to a wall because you're clearly on different pages and you're not having the same conversation. And that's what makes it so difficult because there's no reasoning behind it. But quickly, you mentioned the judicial canons, and if you want a quick rundown of the ones that may be violated, the first motion to recuse has been filed in Galveston, and it's very well done. It's very long, and it lists the canons that his Facebook post, and here's what's really concerning about this. The Facebook post and his new policy on this probation thing is bad, and it's ridiculous, and his defense attorneys were like, you've got to be kidding me. Because it doesn't mention this, but it also takes into account, what do you do with a reduction? Because in order to get a reduced charge, the judge has to approve it, I mean, they have to do the motion to amend or reduce or whatever. And so he knows the original charge. So does that mean no matter how we resolve this, if we can kind of get away from that? Because the bottom line is not every person wants a trial, even if they think that they're not guilty. The thought of a trial scares the bejesus out of them, especially when they're in felony court. But what's really concerning is this isn't the first time he's done this. And that's what's scary.
And it's a separation of powers issue. I don't know if that's been brought up in the motion to recuse, but it's basically asserting authority over the DA's office, which is the executive branch, in their policies about reducing charges and their policies about what to offer. That's an executive function, not a judicial.
Well, I want to touch on that in a little bit, but we got a phone call I want to drop in here and say, hello, thanks for calling Reasonable Doubt.
Three-part question.
Yeah.
Yeah, I have a three-part question. So
You're only allowed one part.
Okay. Well,
No, I'm just kidding.
you all went to law school, right? So
That's what they tell us.
You knew some crazy people in law school, right? And you don't have to answer that quite yet. To be a district judge, you have to be a lawyer or licensed by the state of Texas, at least in Texas, right?
Yes.
And they're all politicians, right?
Correct.
You can answer that one okay, correct. Okay. So why are we surprised that crazy people who got law licenses are now politicians?
I mean, it's a fair point. It's a fair point. Thanks for your call.
You'd make a good lawyer, Paula.
Yeah.
No. You'd make a good judge.
No, but you know, I mean, yeah, it's true. We had a lot of people. You know, I read an article the other day about how many presidents have been practicing lawyers. I mean, the political world is filled with lawyers. But to touch on your point, Sean, about the separation of powers, you know, this Facebook post comes on the heels of our governor talking about how he's going to increase punishment for officer-involved shootings. It's like, time out. It's already a life or death issue.
Right.
I mean, you can't get. What are you going to do? I mean, are you going to dig a deeper hole to bury him in?
That's a legislative function anyway.
Yeah. Yeah.
Or a judicial function. It's certainly not an executive function.
You know, I think the biggest problem here is this. They have this, especially just like the caller said, I mean, they're politicians. And there's been a lot of chatter down in Galveston. And I will say, kind of like you with the prosecutor on Sean's case, I know Judge Neves. I'm in his court all the time. As a matter of fact, I was in his court yesterday. And I do believe he's a good man. I do like him very much. I don't think I don't think he's malicious in what he does. I really just don't think that he gets it. And I think that there's this perception, especially when you're watching the media and you see all of these protests and everyone, like you're saying, coming out, we need harsher penalties and, you know, we've really got to step it up and we've got to protect our law enforcement. Well, we do have to protect our law enforcement. But if you really want to make a difference and you want to start seeing change, I think what you have to do is, you know, the judicial 101 concept, be fair and impartial, because you have to keep the system honest. And until you keep the system honest, which is, as a judge, knocking out the bad stuff and, you know, allowing a good trial to go forward, then that's how it gets down to making a difference on the streets. That's how it gets down to making a difference with how these officers are actually patrolling and how they're interacting with the community. Because if you continue to give them this benefit of the doubt and, you know, protect our law enforcement, you do something against law enforcement, you're going to be punished, then it's kind of this free-for-all that you're allowing them instead of just remaining the checks and balances and calling your balls and strikes. And when a prosecutor brings a case and it's crap, you know, call it like it is. And when it's good, you know, let it go. I mean, that's how I think you that's how you meet your goal.
Right, and the big problem is, going back to the whole political issue, is, you know, they're all clamoring to get the police officers' union vote and get the police officers to support them, and they put it on their website, and, you know, we're the chosen candidate of the police officers' union. Well, why should you be able to even get, one, that sponsor, and two, any kind of donation from that? Mm-hmm. You're sitting in a capacity where you are ruling upon the credibility of officers.
Mm-hmm.
Yeah.
That's just stupid. It's just stupid. It's not even insane. It's stupid. Mm-hmm. That should even be allowed.
You know, and another problem with this whole framework that you've explained, Amber, is that is that the judge, by setting these parameters, is effectively inserting himself into plea negotiations. And there's a broad constitutional principle, it's reflected in federal court in Rule 11, that a judge can accept or reject a plea, but he cannot insert himself into the plea negotiations.
Right.
Which is exactly what he's doing.
Right.
Yeah.
Huh. And you said he's done Facebook posts before or something?
Yes, and if you go look up that first motion to recuse, it has a bunch of the Facebook posts listed, and they've all been the exact same. They're this big support and call for support for law enforcement, and as you were saying about, you know, wanting to get all of these endorsements and stuff, especially because they are politicians, at the end of the order that he just signed that we're talking about, it says, please share with law enforcement and their families. I want them to know what I'm doing for them. But the other posts that he's done are, you know, very supportive of law enforcement, and one of them even says, someone says, you know, people say I shouldn't be talking about this, but I'm going to keep doing it. That's where the problem comes in. And like I was saying, you can't have conversations with people about these, you know, the ones that are behind it, because they just truly don't understand why they're so wrong.
You know, there's this thing, you know, I've been seeing everywhere. It's just be just and love mercy. And like, if a judge could just, what they should just follow those two things, and I think the whole thing gets better.
Yes.
The whole thing just gets, be just and love mercy. Enough of all this, because I think once they take sides, it automatically creates a crossover of powers that shouldn't be there. They're inserting themselves now into places that a judge shouldn't be.
You know, there's a thing, I don't know how many people actually practice it, but you know, there's a saying that you don't send an email when you're really mad. You don't send an email to your opposing counsel. You don't send an email to your spouse or anybody, you know, when you're really, really mad. And usually what I do is I type out the email and put all the bad stuff, and I don't hit send, and I let it just sit there, and I come back, and then I edit it, and I take out all the bad stuff, and then I can send it, you know? And it seems like there should be a similar rule with social media. Like, don't send it out until you've actually looked at this.
Well,
thing.
you would hope. Again, let's go back to Galveston. That's just a complete mess at the moment. The boy in the box. Are y'all all familiar with the boy in the box issue?
Is this like Bubble Boy?
This is like, well, we had a district court judge who was presiding over a jury trial, and they called it the boy in the box trial. Do you know what I'm talking
I
about?
know what you're talking about.
Yes, and the judge is Facebooking about the evidence that they're going to build in the courtroom the next day, in the middle of trial, talking about the box for something that, number one, there's a case going on, so you can't do that. And number two, it wasn't into evidence yet anyways.
Jeez.
Wow.
And you would think, like, can we not learn from that?
Tagging the jurors.
Yeah, like, hey guys, here's a preview. No, I mean, how can we learn from these things?
Well, and how do you expect when you to give instructions to jurors about not to get on social media, not to get on the internet? How do you expect them to follow what you tell them to do when you can't even make good decisions about what you put on social media?
And then the worst part was, because obviously there's complaints and issues, and it goes through the Judicial Commission, and you know they have this opinion that basically says, this is very bad, please don't do this. This is what gives judges a bad name, and it goes against everything your position stands for. And she read it and took it to mean that she was not in trouble and everything she did was fine. And then she posts on Facebook again, hey, y'all should see I'm not in trouble for what I did.
Wow.
And it's like, oh my gosh, you've got to be kidding me.
What do they say? It's like, they say, dance in the rain like no one's watching, or something like, dance like no one's
watching.
But send an email like it's going to be read in a deposition. Like,
Yeah.
I mean, you gotta,
I was always taught never say anything or write anything that you don't want broadcast in a courtroom.
Yeah, exactly. And it's just, you know, I don't know why this is not the first instance, like you said, not just in Galveston County, but around the state. I mean, it happened up in Walker County?
Polk, I think.
Polk County.
Polk
with
County.
The texting.
Yeah. Yeah, you had
Ask this question.
right.
Yeah, it's out of control. Well,
Didn't she resign and then run for DA or something?
Something like that.
Yeah.
And, you know, it's even little things. Like, we were in trial this week. We actually got out. We got a verdict yesterday afternoon. Not guilty. Thank you.
Another not guilty.
Congratulations.
Yes.
First of right here. Yes.
But Galveston has this shadowing program now where officers will shadow the prosecutors. So they come sit in the courtroom and kind of watch what the process is, which I think is great. It gives them a different perspective on what actually happens outside of a trial that they have an interest in. Okay, fine. Well, they also have interns right now because it's summer, so that's fantastic. But we're picking a jury. We're about to start voir dire, and the judge is doing introductions, and there's this extra person sitting at counsel table for the state, and I thought it was an intern. And Tad Nelson, who I try cases with, he thought it was an intern. But no, they had the intern in the jury box watching, and they had an officer sitting with the two prosecutors.
Jeez.
Okay, well, we didn't know at the time. Unfortunately, the judge just said his name, and we finished voir dire. We're about to start doing our strikes and all that. And he stands up, and I see a gun and a badge coming from counsel table over for the state, and I lose it. I'm like, oh, this is not okay. And Tad looks, and he's like, this is not okay. And so, we get the judge, and we're like, we're going to ask for a mistrial right now because you can't have an officer sitting there shadowing when, number one, everything we're talking about going around the country, support for law enforcement. Yeah. And then you're going to have an officer testify who is our only witness. What about credibility issues? And the judge was like, well, he's just shadowing. He's just learning. And we were just floored.
What's going on?
And fortunately, it took her about 30, 45 seconds, and we saw the light bulb go off, and she was like, oh, that's very bad. You got to go. You have to go. But, I mean, it's just, what is happening?
Wow.
How did it even take 30 or 45 seconds, and how did the state let that happen even? And they thought that we were the bad guys because we're taking out their, the guy shadowing them. How could you do that?
Someone, and to note that someone's making that call saying that's okay.
Yes.
At some higher level, someone's saying, no, that's perfectly fine.
Yes.
On a side note, and I know we're running out of time, but they're the two psychologists. They pled guilty to I think it was a tampering charge. They weren't properly interviewing new recruits for HPD, and they weren't. So the psychological exam that they were supposed to be doing, they weren't doing it correctly, and so for years they were allowing individuals to become gun-wielding, badge-wearing police officers without proper psychological evaluations and screening. So it's like we're wrapping out. It just came up. It would be a great story to talk about.
Yeah. I'm floored. It's just
I bang my head sometimes.
Bad, poor decisions, I think, is the theme. We should nickname this episode "Poor Decisions" because that's what it's all been about.
Except the two great ones that are
That's
here
right.
today.
Having these two on the show. Well, Sean, Amber, we thank you guys for coming.
Thanks for having us,
It's
guys.
been
Thank you.
It's been a real good
great
show.
This was a lot of fun. Thank you very much.
show.
Julio, we got Kim Ogg next week.
I'm nervous, man.
Why are you nervous?
She's big time. I mean, they're big time, but Kim
but
Ogg.
you got great hair.
That's true.
for the show.
That's true. I think I'm gonna wingtip it for next week.
You're gonna wingtip it?
Yeah.
Okay.
I don't know.
Just
No.
don't do any more movie spoilers for people. You ruined Zootopia for people who haven't seen it.
It's the classic
You've
thing
given away the plot to Zootopia.
about doing the wrong thing for the right reason.
I don't care. I haven't seen Zootopia, and now you've ruined it. That's all the time we have for tonight, ladies and gentlemen. Please go check out our website, www.hcclatv.com. You can see all our past episodes and check out all our great blog entries. We'll be back next week, like I said, with Kim Ogg. Good night, everybody.